Well, good afternoon, everybody. Thanks for coming to today's CLE on the top 10 pitfalls on appeal and how to avoid them. My name is Tim Droske. I'm the co-chair of Dorsey and Whitney's Appellate practice group here. And I just want to encourage everyone, if you haven't already, there are green sheets at your table. If you can just sign up to make sure you get CLE credit, that'd be great. So again, thank you everyone who's here in Minneapolis and everyone who's joining us by webinar for coming to today's presentation. You know, anytime you're putting together a top 10 list, there's kind of the fun challenge of how you're going to order things. Are you going to start with kind of the most egregious thing and then go down to the least egregious, or do it in the opposite order? What I've decided to do here for today's presentation is to identify kind of 10 top pitfalls and march through the timeline of an appeal as kind of the organizational tool. So we'll start out by identifying some things that can trip up attorneys or clients early on in the appellate process, and then march all the way through the briefing process, oral argument, etc. So with that, we can jump right in. Pitfall number 1 is failing to appeal or cross appeal. And this sounds pretty basic, but it's something that can really happen. Appeals are initiated by filing a notice of appeal, a one-page document that's really pretty simple and simply identifies what court you're appealing to and what orders or judgment it is that you're appealing. Where parties can get in trouble is by, later on in the briefing process, trying to raise an issue on appeal based on an order that was not identified in the notice of appeal. And so the 8th Circuit recently, for example, stated the basic proposition: where an appellant specifies one order of the district court in his notice of appeal, but fails to identify another, the notice is not sufficient to confer jurisdiction to review the unmentioned order. There's a simple solution to avoiding this mistake, and that is, anytime that a final judgment has been entered in a case, make sure that your notice of appeal is identifying the final judgment as what it is you're appealing to the Court of Appeals. Because the rule is that the final judgment subsumes within it every other order that was issued in the case. And so, for example, you know, if you want to appeal a summary judgment order, don't just identify the summary judgment order in your notice of appeal. Identify the final judgment that was entered by the court and all orders subsumed therein, including but not limited to the summary judgment order. And then if once you get to the briefing process stage, you realize that maybe you also want to raise an issue that came up earlier in the case, you know, failure to grant leave to amend or some other procedural issue, because you've appealed from the final judgment itself, the court will have jurisdiction to entertain it. Another pitfall with respect to kind of just the appeal initiation process that has come up now with e-filing and e-service being the norm are some of the trappings that come with it. It's really convenient to, you know, look at your inbox on your email and see that, you know, a document's been filed by the district court, and it has a little, you know, subject heading description of what it is that's been filed, and then you have to click on a link to actually pull up the PDF order that's behind it. The problem that can come up is by relying on the email subject heading for what that document actually is, as opposed to opening the document to see what's behind it. That came up a few years ago in a multi-million-dollar jury verdict. The party that lost was planning to appeal, but first brought a number of post-trial motions, which you're allowed to do before filing the notice of appeal. And the rules of federal appellate procedure are that once the last of those post-trial motions is adjudicated by the district court, that's when the notice of appeal period clock starts to tick. So what had happened in that case is they had filed a number of post-trial motions. They had also filed a motion to file all of those under seal. And, you know, sometime later, they got one of these, you know, email notifications saying that an order had been issued on the motion to file under seal. No one cared about that motion in particular, so no one clicked on the link. If they had, they would have realized that the PDF order actually also, you know, adjudicated and reached the final decision on all the post-trial motions. By the time the attorneys had realized the mistake, the 30-day period to file your notice of appeal had lapsed, and they ended up finding themselves without any sort of ability to challenge this multi-million-dollar jury verdict before the Court of Appeals. So, simple way to avoid that one: click on the links anytime you get something in your email inbox. Another thing that's happened to me recently with e-notifications is spam filters. The U.S. Supreme Court has recently gone to an e-filing system, and it's not the official filing or service system, but it's there as a convenience for the parties. When I first signed up, Dorsey spam filter was taking all those notifications and not putting them in my inbox. So fortunately, there again, we'd still get paper filings, letting us know that anything had been filed or served. I was on teams with other attorneys, so I was always hearing about what was happening. But I was I was listed on the Supreme Court's docket as an attorney, but my spam filter was picking all those up. So if you're a Dorsey attorney, once a week, we get kind of a listing of everything that's been caught in the spam filter. It's critically important that you look at those to make sure that nothing from an actual court is getting caught through your spam. Another trap in terms of failing to appeal is just counting the days correctly. More than anything else, that's a jurisdictional bar. If the federal rules give you 30 days to file the notice of appeal and you file on day 31, the Court of Appeals does not have jurisdiction and they don't have any sort of equitable authority to extend the time. That happened recently in this FCC case that was appealed up to the Federal Circuit. There, it was right around the time of the government shutdown. And so the FCC issued its order, government shuts down, there's either 30 or 60 days to file the petition for review to the Federal Circuit. The party who had lost assumed, government shutdown means that the clock stops ticking. And in a very short, kind of one paragraph per curiam opinion, the Federal Circuit said, no, you're wrong. The government shutdown had no impact on the appellate clock ticking. You're out of luck in terms of us being able to consider your appeal. So if you have any doubt at all in terms of when you need to file your notice of appeal, make sure you're filing early. That can come up with respect to post-trial motions. It can come up with respect to counting weekends, counting holidays. When in doubt, make sure you're filing early, because it's one of those things that the Court of Appeals, no matter how sympathetic you are, is going to have to say, we just don't have jurisdiction to hear your case. There are a lot of the same kind of pitfalls with the cross appeal, but the one unique thing that comes up frequently on the cross appeal is that there's this appellate doctrine saying that the Court of Appeals can affirm on any alternative bases that's supported by the record on appeal. And so you always have the question, if you're the respondent or the appellee, of whether you can raise an alternative ground for affirmance without having to actually go through the mechanism of filing a cross appeal. The general rule of thumb is that so long as the alternative argument you're raising is not going to change the judgment at all, you're fine raising that without bringing a cross appeal. But it can sometimes get a little bit tricky. So, this 10th Circuit case that I have a small quote of, the alternative ground for affirmance was like another basis for a 1983 action, and the court said it would have enlarged the party's rights because it was kind of an independent basis and could have had its own damages, et cetera. And so the court said, sorry, we can't consider it because you didn't raise a cross appeal. It would have enlarged the judgment. So that's the general federal rule. If you're in different state jurisdictions, you need to be even more careful, and Minnesota is a prime example of that. It has the same general rule that, so long as the alternative basis for affirmance is one that's supported by the record, not going to affect the judgment, you don't need to file a cross appeal. But there's one extra wrinkle, and that is if the district court expressly rejected your argument. So for example, if you're a defendant and you bring a motion for summary judgment on breach of contract, and you say, there are 3 different reasons we win. And the district court says, well, I agree that you win because of reason 1, and doesn't go on to address the other 2. It says, and for that reason, I don't need to address the other 2. Then you're fine. You can raise issues 2 and 3 without filing a cross appeal in Minnesota or federal court. If the district court said, I agree that you win on reason number 1, that the breach of contract claim fails, but I expressly rule against you and find that on your second and third reasons, you don't win. In the federal court, again, you could still just raise those as an alternative basis without filing a cross appeal. In Minnesota, you would need to cross appeal on that because the district court affirmatively found against you. So those are some trappings early on in the case. There are a few others that can come up early as well. And waiver and forfeiture of arguments is one that trial attorneys are always scared of. Appellate attorneys are often kind of pulling their hair out saying, we wish the great argument would have been raised below. Here are some examples of where waiver and forfeiture can come up. Just this past term in the Supreme Court, there was this Emulex case that was before the court. It was a private Securities Act claim that was brought by a private litigant. And the issue that had been before the Ninth Circuit that had created a circuit split and then was raised in the petition for writ of certiorari was what the pleading standard should be for a private litigant as opposed to the government in bringing one of these claims, whether it should be a negligence standard or some sort of scienter requirement. When the court, after the court granted cert and once there was merits briefing and then an oral argument, court watchers were saying that what really seemed to be grabbing the court's attention was the bigger question of whether there should be a private right of action at all under Section 14E of the Securities Act. And everyone was then kind of surprised when the court's decision was a one-sentence order dismissing the petition as improvidently granted. And the court doesn't provide any of its reasoning, but again, what court watchers speculated happened here is the court got concerned that the issue they ultimately were caring about the most was one that wasn't raised before the Court of Appeals, wasn't even squarely presented in the petition for a writ of certiorari. And so the petitioner there may have had a winning argument, but ultimately they're stuck with the Ninth Circuit's ruling because the issue wasn't squarely put before the Ninth Circuit or the Supreme Court at the right time. Again, it's important that you raise issues at the right time in order to preserve them for appeal. So, as a defendant, you may be drafting a brilliant summary judgment brief on a clean legal issue, and you might devote, 30 pages to this legal issue. But if the court denies summary judgment and the case proceeds to trial, you need to re-raise that issue, at least certainly in the Eighth Circuit, in order to be able to raise it on appeal. In this Lopez v. Tyson case, the Eighth Circuit made clear that a denial of summary judgment is not appealable after a final judgment, regardless of whether the issue is factual or purely legal. There are some other circuits that will say, well, if it's a purely legal issue, it's not going to matter really whether the record evolves from the summary judgment stage to then what happens later on at trial. And so a motion for summary judgment may be enough to preserve the issue, but that's not the case in the Eighth Circuit and isn't going to be the case in every jurisdiction. So be wary of those kind of traps. There are also a number of issues that arise in terms of properly objecting and preserving arguments when you get to the trial stage. The general rule of thumb to always keep in mind is if it wasn't put before the district court, you can't raise it for the first time on the Court of Appeals. And raising an objection early on in the litigation process doesn't necessarily preserve it throughout the rest of the district court proceedings and on appeal. So again, raising something at summary judgment means you still need to raise it as a judgment as a matter of law. Even if you've objected at trial, during trial like you should, raise those same arguments in a post-trial motion for new trial, for example, to make sure that they're squarely preserved and presented to the Court of Appeals. In addition to just making the objection at the right time, you need to make sure that your objection is sufficiently detailed for the court to know what it is you're objecting to. You often will need to specify the relief that you're seeking. So for example, if you object to the other attorney's misconduct at trial, you often may need to ask for a mistrial in order to preserve that issue on appeal, when you're arguing for a new trial and a post-trial motion and then on appeal. You also just need to be careful to the extent that there can be, talks about jury instructions back in chambers. Make sure your objections actually get memorialized on the record on appeal. And the best way to try to make sure that you're protecting yourself against these waiver and forfeiture arguments, especially once you know that this is a case that's likely to go on appeal or you're heading into trial, is to have an attorney there who's specifically focused on issue preservation. It's going to be hard for the lead attorney who's focused on winning at trial in the heat of that moment to also be thinking about all these issue preservation concerns that may come up. So have another attorney who's focused on that. Pitfall number 3 is one that, again, you need to be thinking about at the district court stage before you even get to the Court of Appeals. And this is overlooking the record on appeal. The general rule of thumb that can trip attorneys up is the basic principle that if it's not in the record on appeal, a fact for all practical purposes doesn't exist. The Court of Appeals is going to be looking at specifically the facts that were put before the district court and are in the record on appeal that's sent up to the Court of Appeals. If a fact isn't in there, in theory, it shouldn't rely on it, it can't consider it, it doesn't exist. And so there are some things that come up early on in the appellate process and that you need to be thinking about in district court to make sure that you have an adequate record on appeal. One is the ordering of the transcripts. You know, if you've gone through a trial, it's probably going to be a no-brainer that you should order all those transcripts. But if the issue that you're going to be raising before the Court of Appeals is one that involves an abuse of discretion standard of review, if there was any sort of hearing on the motion that you're objecting to, it's critical that you order that transcript. Otherwise, the Court of Appeals is likely to say, we're not able to determine whether or not the district court abused its discretion because we don't have the record in front of us to see what the district court considered. And they're not going to remand to give you an opportunity to kind of flush that out. Instead, it will just be a summary affirmance. So order the transcript anytime you have any sort of scintilla of doubt as to whether it might be relevant to the appeal. The other thing you might need to be thinking about are exhibits. If one of your main arguments on appeal is going to be that the district court refused to admit into evidence the key exhibit that would have made all the difference, you better make sure that it's admitted to the court as a trial exhibit that's going to get up to the Court of Appeals, even if it was never shown to the jury. Because if that doesn't happen, that exhibit doesn't exist for the Court of Appeals purposes. Likewise, if you're, let's say, doing a products liability case and you want the Court of Appeals to be able to hold the product in question, right? And there was a physical copy of that that was admitted to court in the district court. You may, depending on the jurisdiction you're in, that might not be automatically sent upstairs. And so that might be something that you may need to request gets sent to the Court of Appeals if you want them to be able to, again, kind of examine that exhibit for themselves. Now, if you find yourself in the position where you have a great fact that or interesting fact that you want to get before the Court of Appeals, but it's not in the record, that doesn't mean that all is lost. There are a few different ways that you can try to get those before the court. One is you can try to use certain online sources and just cite the URL right in the brief itself. I can tell you different Court of Appeals judges have very different views on how proper or improper this is. I think the general rule of thumb is that if you're giving kind of big picture background facts on kind of the landscape here, those are going to be more okay than something that's, you know, here's the URL to the Google Maps address of where the, of where this incident occurred. To the extent that the online source you're citing to looks more and more like the kind of legal source that you might put in the table of authorities, the stronger the footing you're on. And so, you know, sometimes I represent foreign governments that are being sued in the United States, and you know, and sometimes we'll pull up State Department reports, for example, and you know, usually we've been okay in doing that. Other examples would be, you know, if the USDA, for example, has published a 100-page guide on some sort of area of agriculture, and you're doing an agricultural-related case, providing, you know, the URL and citing that's probably going to be okay too in most instances. You can also bring a motion for judicial notice, and you can do that with any of these online sources you're trying to bring to the court's attention if you want to, and sometimes that's a good belt and suspenders approach. Motions for judicial notice are also effective, particularly if you're trying to direct the court's attention to something that's happening in another court proceeding. So it's not in the record on appeal here, but you know, this party has also been sued in this other jurisdiction, for example. So a motion for judicial notice is the way to go about doing that. The quote I have at the bottom here from the Fifth Circuit kind of illustrates all the different traps that you can potentially run into. So this was a case where it was a prisoner who was trying to, you know, seek some sort of relief from the Fifth Circuit for his treatment, and the warden here was saying, well, he had a number of different procedural avenues he had to exhaust first before he went up to the Court of Appeals. Court of Appeals looked at that and said, well, it's fine that you say that there are all these kind of internal grievance processes that he had to exhaust first, but you never put that before the district court in terms of it being part of the record on appeal. It said, okay, but well, that's not fatal here. We could go online because, you know, you have these processes published online, and we can take judicial notice of that. But then it went there and saw that the year that they had, the only year they had available online was already after the incidents had occurred here. And so they said, sorry, you know, we just can't find the source that you need to, that you're saying is dispositive of the exhaustion of procedural remedies you lose on that ground. And so ways that could have been avoided would have been putting it in the record, or even if relying on an online source, if they had found it online earlier, actually printing out that PDF, filing a motion for judicial notice that would have given the paper copy to the court. So even if the URL gets changed later on, it's there fixed and in the court's hands. Another thing you can do is use amici. Amici are friends of the court. They can bring different facts before the court, sometimes even filing an affidavit. And so, especially if you're cooperating with amici, that's another way to bring background facts before the Court of Appeals that may not squarely be in the record. So now that we're kind of past some of these early stages in the appellate process, one of the first things you'll need to be thinking about in terms of writing the brief is what issues it is that you're going to be raising before the Court of Appeals. And failing to properly narrow and identify the right issues is certainly a key pitfall that can happen when you're in appellate court. And this is one of those things where you kind of have this pendulum, and the danger is being caught at either extreme. On the one hand, you don't want to be throwing mud against the wall by raising, 10 different issues and just trying to see what sticks. The Court of Appeals is going to see through it, and you're unlikely to have enough time to actually develop any of your issues sufficiently to actually be persuasive. On the other extreme, you don't want to be so laser focused in the issues you raise to leave behind an issue that actually may have caught the court's attention and gotten traction and would have been the winning argument. And the quote below here from Judge Wood on the Seventh Circuit kind of illustrates the difficult balancing act. Affirming that one of the most important parts of appellate advocacy is the selection of the proper claims to urge on appeal. Throwing in every conceivable point is distracting to appellate judges, consumes space that should be devoted to developing the arguments with some promise, inevitably clutters the brief with issues that have no chance because of doctrines like harmless error or the standard of review, and is overall bad appellate advocacy. But on the other hand, counsel can't throw the baby out with the bathwater. So in terms of avoiding this, there are two different things to be thinking about. One is what's the right number of issues to raise, and the other is what are the right kinds of issues to be raising. In terms of the number of issues, I think generally appellate practitioners would agree that 2 to 4 is kind of a nice sweet spot to be focusing on. Maybe you have just one great legal issue and you want to run with that all the way through. That's fine. But for me personally, at least early on in the strategy process, the drafting process, if I've identified one issue, I'm going to at least think about what other issues I may also want to raise, because I'm likely going to have space for it. And sometimes you want to group legal issues to group issues together so they tie in with a common theme. I was involved in a case where the main theme was that the jury awarded a substantial verdict because the case had gone sideways because plaintiff's counsel was trying to pull one over the judge, pull one over the jury. And the main legal issue that we thought would be compelling on appeal was what was the experts. You have kind of issues of law intersecting there. It seemed like a better appellate argument. But we also raised issues relating to what we said were examples of plaintiff's misconduct. Even though that's an abuse of discretion standard, unlikely to probably carry the day on appeal, we thought it tied in with the theme well, and we had the space to do it. Another thing to think about if you have a lot of issues is whether there are ways that you can group them together to all of a sudden go from having what looks like 7 different issues down to 3. For example, if you're raising issues of attorney misconduct, you may have 3 different examples, but you could just have the general heading of attorney misconduct rather than parsing those out as 3 different issues. If you're raising a preemption challenge, there are 3 different bases, there are 3 different forms of preemption. Instead of having 3 different issues, you could just have one issue, is it preempted, and then have subsections under that. In terms of raising the right kind of issues, we'll be talking about this a little bit here. Complaints that the other side didn't fight fair rarely win. And so I know I was just talking about like attorney misconduct. Usually that's not a winner on appeal. Maybe that's more of a supporting argument. Instead, what you really want to be focusing on are broader legal issues. It's at the district court. The district court's going to be focused on the facts. The Court of Appeals is focusing on law. And so if you can identify legal issues, frame your issues in a way that are certainly relevant to the case at hand, but also raise kind of broader implications as a matter of law and precedent, that's important to try to do when you're trying to discern which issues to raise. And like I gave the example earlier, to the extent that some of your issues can dovetail and fit together, that can be persuasive, especially as you're trying to develop and weave it in themes that carry on from the statement of facts and statement of the case all the way through the legal argument. Another critically important thing to think about when you're raising your issues on appeal is whether the issues you're raising are actually going to give you a meaningful win if the court finds for you. So, for example, if you're the defendant and you've lost at trial on 3 different claims, you may have a slam dunk argument on appeal for why there was insufficient evidence as to count number 1. But if that's the only thing that you raise on appeal and you have counts 2 and 3 that are providing the same damages, who cares, right? You need to make sure that you're raising issues that are going to attack all 3. Maybe you have, 3 different issues, count 1, count 2, count 3, or maybe there's an issue that, if a thread on the sweater where if you pull that, the whole thing falls apart and the entire jury verdict disappears. So you need to be thinking about that when you're determining which issues you're going to raise. Pitfall number 5 is related to the statement of issues. It's ignoring the standard of review. This is something that's critically important to be thinking about when you're putting together your issues. The standards of review really do matter. And I've heard it from appellate judges time and time again at different CLEs. I think especially Court of Appeals judges who were trial judges before they went on the appellate bench are attuned to the fact that, if I had the jury in front of me, the witness in front of me, the attorneys in front of me, on these facts, I probably would have done something different, but this is an abuse of discretion standard, not de novo review, and so I'm limited in terms of what I can do here on appeal. You'll also have appellate judges who feel like they have a very full docket, and so they're looking for ways to kind of quickly dispose of appeals as succinctly as possible if they can. And if they see standards of review being argued like clear error, abuse of discretion, it can be much easier for them to go in thinking, okay, well, this one's a likely affirmance, and push it off their desk. And if you're the party seeking reversal, you want to do everything you can to avoid that. So de novo review is the gold standard. That's what you want to be looking for. That's where no deference is given to the district court. And this applies to kind of clean issues of law, as well as where the facts are set. And so judgment as a matter of law, for example, is kind of one of these hybrids, right, where you need to construe the record in the light most favorable to the party that won on the verdict, but it's a de novo review in terms of whether on those facts any reasonable juror could find for the party that won. Summary judgment is another kind of classic example of that. And you can see at the bottom, in the Eighth Circuit, these standards of review matter. Reversals don't happen very often, and when they do, it's twice as likely to happen on de novo review than abuse of discretion or clear error. Abuse of discretion, it's harder to win on, but sometimes you can. The key here, again, is to try to focus as much as possible on a legal error that the district court made, because there's kind of this principle out there that a district court inherently abuses its discretion if it applies the wrong rule of law to whatever decision it's making. So again, if you can cast it as a legal issue, you're going to be on much stronger footing. Conversely, if you won below, you want to do everything you can to try to frame the standard of review as abuse of discretion and not de novo. Clear error is one that really you should probably just avoid and not raise as an issue. A judge in the Seventh Circuit used this quote that I think every other circuit has adopted, including the Eighth Circuit, that for there to be clear error, it must strike us as wrong with the force of a 5-week-old unrefrigerated dead fish. It's going to be a hard standard to meet. What you want to try to do in your appellate arguments is say, even taking the facts as they are, as they were found by the court, as they were found by the jury, every inference, as a matter of law, we still win because X, Y, and Z. So then continuing to kind of move on to the briefing and advocacy stage, motion practice, oral argument, et cetera. A pitfall that I see can come up frequently is the trap of litigating in the Court of Appeals like you're still in trial. And this can take on a number of different forms. One is kind of this focus when you're doing the briefing on how the case was argued below, rather than the central legal issues that are now being raised before the Court of Appeals. And so briefs like this will say, we'll focus on, at summary judgment, the other side argued X, Y, and Z and cited these cases. We then cited these cases in response, and we win because, fill in the blank. The Court of Appeals doesn't want to see briefing like that. They want you to, you've raised a legal issue that has, that needs to be settled for this case and is also going to have ramifications for other cases in the future. They don't care about how it was briefed at summary judgment or motion to dismiss or post-trial. And the proof of that is actually in the federal rules themselves. So Federal Rule of Appellate Procedure 30 is the one that governs the appendix. In the appendix, the goal of the appendix is to take kind of the most important parts of the record on appeal and get them in the judge's hands as easily as possible. There's only one thing that the rules say absolutely should not be included in the appendix, and that's the lower court briefing. They don't want to see it, okay? So the way that you avoid that is by, instead of focusing on how it was argued, affirmatively just say why you win. Use the cases, use the facts, and just make your pitch. And then when you're trying to talk about what happened below, focus on the district court's order and why it was rightly or wrongly decided, as opposed to what the parties argued to the district court to make it come to the decision it did. Another pitfall along the lines of litigating like you're still in trial is a focus on the facts while minimizing the law. Trial is all about the facts, right? I mean, it's what evidence you can get before the court, trying to tell your persuasive story and getting the jury or the judge to agree that the way that you say it happened is what happened. At the Court of Appeals, it's the law that is going to be the driving force behind who's going to win and who's going to lose. And so, if you're someone who falls into the trap of kind of focusing a lot on the facts, even when you're at the appellate stage, I think just a general rule of thumb is, as often as you're citing to the record on appeal in your statement of the case, make sure that you're also having legal citations just as frequently. At a minimum, one paragraph, sometimes at the end of every sentence, but make sure you're citing cases throughout to support your propositions. And I think an example of how the law really needs to drive the issues at the appellate court is when you look at good reply briefs. So if you were to pull up Solicitor General briefs, reply briefs to the U.S. Supreme Court, for example, even though the other side will have said, in their statement of facts, half the brief will be the statement of facts, and it'll be filled with things that you're going to disagree with on reply. You'll never see a good reply brief that dedicates page after page to why the statement of facts is wrong. Instead, they go right into the legal issues and then interweave all those factual disagreements into how they're casting the legal argument. Another kind of trap on appeal is, if you were the trial attorney, is just fixating on all the little things that went sideways. I mean, if you were the trial attorney, you may have been living and breathing this case for years and years and years. You're going to know everything inside and out. And it's inevitable that you're going to think that the Court of Appeals is going to care about those things too. The problem, though, is the Court of Appeals has sent a clear message in the past 5 years or so saying, we don't want to hear it. The word limit was always tight on appellate briefs. 14,000 words, which is somewhere around, 50 pages or so. And when you're dealing with complex litigation that's gone on for years, that's a lot to try to cram in that amount of space. The U.S. Courts of Appeals response back in 2016 was to say, let's give you even less words to do it. So they went from 14,000 words down to 13,000 words. The Supreme Court, where you'd think, these are the complex cases, right? They said, hey, we kind of think that's a good idea. And so this upcoming year, their word limit is going to go down by 1,000 words, even though these are the most complex, important issues for the High Court of the United States, and they only take 70 of them a year. They're tired of reading. So make sure that you focus on the important things. And the best way that you can do this is, if you're the trial attorney working on the appeal, bring in an appellate practitioner, or at a minimum, someone who's new to the case when you're putting together the appellate briefs. Because that's going to be the same position that the judges are in, or their law clerks when they're reading the briefs. And they're going to be able to identify issues of, the dots just didn't connect for me here. And it may be that it actually doesn't connect to anything. It's an unnecessary fact that can be deleted, or it's something that needs to be flushed out a little bit more. And so get that outside set of eyes to help with the brief. And that ties into the other thing. You know, in terms of how you write the brief, there can be a trap of arguing like the Court of Appeals judges already know the case. They're certainly not going to know the facts of your case. And unless you're in the federal circuit, which is dealing with patent appeals all the time, they're also not going to be intimately familiar with the law either. You know, they're dealing with criminal issues one day, and then contract issues and constitutional issues. They're all over the place. They're generalists. So you need to also educate them on the law, especially when the practical reality is that you have recently minted law graduates who are often going to be doing the lion's share of the work and reading the briefs, drafting the opinions. So you need to make sure that it's understandable. These may be complex cases, but it needs to be boiled down to a very kind of basic level at the same time. And then kind of the last pitfall along these lines is trial. You know, there's a certain theater to it, and I don't mean fakey in any way, but there's drama, right? You don't have fun TV shows about appellate law. You know, you have them about trials. And the reality, especially at oral argument, is you're given a very limited amount of time. 15 minutes is actually kind of long for a Court of Appeals argument, or certainly standard. And it's much more like an academic dissertation you give for a PhD. So you just need to have prepared in a way that you're ready for that kind of court presentation as opposed to what you might be more familiar with before the trial court. Next pitfall is not properly dealing with the district courts or the other side's arguments. And this is one where I'm going to focus, you know, kind of primarily on the briefing process. This is another one of those pitfalls where you kind of have this pendulum and you just want to be careful not to be caught at either extreme. The pitfall on the one hand is ignoring the district court's reasoning and the other side's arguments in the brief. And as the Seventh Circuit pointed out in one of their opinions, this kind of brief is like two ships that pass in the night. Both parties focused on entirely different matters, failing to address the core arguments of their respective opponent. The danger, if you've written a brief that is one of these ships passing through the night briefs, is that the Court of Appeals is going to need to address the arguments in writing its opinion. And Court of Appeals judges and their law clerks, they're always inevitably going to be doing a little bit of lawyering on their own. If you're the attorney and the advocate, you want to do as much as you can to make the court honed in on your reason why you win, right? These are the important cases. This is why the other side is wrong. And if you're ignoring the other side's cases or ignoring the district court's opinion, you're just inviting the Court of Appeals judge to either adopt the other side's argument wholesale or else try to lawyer it up on their own. And that's what you want to avoid. The danger, though, is when you go too far to the other extreme. And this is where you let, you know, the district court's decision frame how you're presenting your entire argument in your brief. Or when, you know, if you're the respondent, you're letting the other side's opening brief completely dictate why you win now at the Court of Appeals, even if now the structure is looking completely different from how you presented your winning argument before the district court. Again, the happy medium is to find the middle ground here. And the way that I do it, certainly when I'm kind of first drafting the brief, is to start out in your legal argument by affirmatively stating why you win. Don't focus too much on the district court or on the other side's arguments. Present what the precedential law is, present what the critical dispositive facts are, and make your case. And after that, you know, the Court of Appeals is going to say, oh, that makes a lot of sense, this seems right. And then you can kind of go through, you know, the other side's arguments or where the district court went sideways and say, this fails because of this fails because of that, and hopefully the Court of Appeals is tracking at that point. Now you can certainly, you know, do that in a lot of different ways. Sometimes you can interweave those arguments. It doesn't always need to be a straight, you know, start here, but make sure that you have both, and making sure that you have both of those aspects will avoid either, you know, being caught at either of the extremes. And actually, I think if you read Supreme Court opinions, I think a lot of the justices do a masterful job of kind of structuring their opinions in this way. You know, they'll go on for pages and pages about all the compelling reasons they win, and then it's at the very end that they kind of, you know, say, oh, and the dissent's wrong because of these reasons. And, you know, often you're nodding your head until you read the dissent, and then you end up going in the other direction. A few other mistakes that kind of commonly come up in briefing when you're trying to, you know, convince the court and make your case that I see are citing the wrong cases. And so, you know, often I can look at a party's brief, and without knowing anything about the case, without having looked up any of the cases, just by what authority they're citing, you know how strong their argument is. If you're at the U.S. Court of Appeals and you're citing district court decisions for why you win, you probably have a pretty weak argument. Or at a minimum, at an absolute minimum, it's a question of first impression for the circuit. To the extent that you have precedential authority that you can be relying on, start with that. And then you can backfill by saying, oh, and this result makes sense as XYZ district court may have found. But as a general matter, you can probably toss those district court opinions out. They're not going to be compelling to a U.S. Court of Appeals. Another danger that really comes up in Minnesota a lot is the Minnesota Court of Appeals issues very fulsome opinions, but only about 10% of them are published or precedential. 90% are unpublished. And they're all available on Westlaw and Lexis. And when you're doing your research, you'll find a 20-page unpublished opinion with a dissent or concurrence, and it has a great kind of statement of what you want, the perfect quote for what the black letter law should be in Minnesota. And so you're like, why shouldn't I use this? And the reason is because the Court of Appeals means something when they say it's published versus unpublished. Even though the opinion looks just as fulsomely written and analyzed as the published opinion, if it's unpublished, it's non-precedential. And so you want to make sure that certainly the cases you're citing for what the black letter law is, when you're quoting that 4-element test, you want to make sure it's coming from a published precedential decision. Now, if the case that's on all fours factually is an unpublished opinion, you can mention that in the next paragraph as persuasive authority, and you can make all the arguments for why there's no reason for the Court of Appeals to go in a different direction here. But make sure that you understand the importance that the Court of Appeals judges are going to be putting on the cases that you're citing. Another thing that is often absent in appellate briefs because it's not necessarily expressly required in the different sections of a brief you need to include is having something that succinctly summarizes your argument for why you win. You know, the reality is you're going to have like a 50-page appellate brief with all these different sections, and the Court of Appeals is going to have, a stack of different briefs in the same case. And it can be very hard sometimes to pinpoint precisely why you win. Or it might take, the court a lot of time to get to the part in the brief, past the facts, past the statement of issues, where they actually understand your legal argument. The rules expressly allow for a summary of the argument. Make sure you take advantage of it. And always try to do more with it than just kind of succinctly march through the headings of what your argument section is going to be. Consider this like your elevator pitch. And instead of just using a sentence or a paragraph on each issue that you're raising in your brief, try, in the first draft, try to use a page. And so if you're, writing a 2 to 4 issue brief, have your summary of the argument be 2 to 4 pages long as opposed to 1 page long with just a couple of paragraphs. Another thing that you can include in your appellate brief, even though it's not expressly stated in the rules, is an introduction. Right on page 1, you could start with a couple paragraphs. It could be a page or two, explaining to the court what are the, a basic summary of what the facts are of this case, what the issue is that arose before the district court that you're putting before the Court of Appeals, and why you should win. And that can be great to have on page 1, because otherwise page 1 is going to be statement of issues, jurisdictional statement, then getting into the statement of the facts. And it's not going to be until, page 25 of your brief where maybe you're starting to get into the argument. So an introduction can do a lot to kind of focus the court early on. All right, back to pitfalls here. Pitfall number 8, this is something that can carry through kind of the entire appellate process. It's what I characterize as being unhelpfully adversarial at the Court of Appeals. This can take on a few different forms, and we'll talk about it here. One big no-no is trying to sneak something by the Court of Appeals, and we kind of touched on this earlier on. If you know that there's that bad case out there, especially if the other side's identified it, or there's that bad fact in the record below, don't just hope that the Court of Appeals doesn't catch it. The reality is that the law clerks are going to be looking at the case law independently. They're going to be, and getting on Lexis or Westlaw on their own. They're going to be scouring the record, and you certainly have some judges who have a reputation for being kind of record hawks and looking at it very closely. And the last thing, you're going to take a big credibility hit if the judge or law clerk finds what they think is the dispositive case that seems to go against you, but you ignored it, or same thing with the real bad fact that occurred at trial. And the other danger too, again, is that if you don't explain that bad fact or that bad case to the court, they're going to be trying to come up with how it cuts in this case on their own. And you don't want that to happen. You want to be able to make your best pitch for why you win on appeal. So make sure that you're addressing the tough facts, cases, and arguments, and make sure, with your overall brief that you're doing all this in an organized way that makes sense. This goes to kind of a broader issue, but judges more and more aren't reading kind of your old paper-bound briefs. They're flipping through screens on their iPads, things like that. And so having a poorly organized brief can really hurt, especially when you think of how you read things electronically. Headings and subheadings really pop out. Don't bury your arguments. Make sure that they're presented cleanly, and use headings and subheadings as much as possible to kind of break up the flow and clearly hone the court in on where you're addressing a particular point. Another thing kind of along the same lines is make sure that you try to provide cross-references to the other side's brief or the district court's order when you're making your arguments. It's going to be the law clerk's judge to kind of put together a bench memo saying how everything kind of talks to each other. You just saying as the other side argued, and then you make your case without providing kind of a pin site to where they made that argument. It's going to make it a lot harder for the clerk. They might be cursing you by the time they're done doing the bench memo. If you can clearly direct them to the pin site in the other side's brief where that point was being made, you're going to make their job a lot easier. They're going to like you a lot more, and they may actually want you to win then too. So another example of being unhelpfully adversarial on appeal is taking cheap shots at or speculating regarding what the lower court did, what the lower court was thinking, or the same too for opposing counsel. The reality, at least in terms of, going after the district court judge, it's the Court of Appeals' job to correct the district court when they go wrong, but these are also their colleagues. They're often in the same building as these district court judges. And so the Court of Appeals generally isn't looking to throw them under the bus. And so as a general matter, you shouldn't either. And at some point it looks more unpersuasive for you to say, the district court judge here was crazy and off in left field, and look at all the crazy rulings, or they must have been thinking this, that, or the other thing when they ruled this way. At some point it looks like you're just kind of a curmudgeonly, grumpy person who lost below and is just mad at the world, as opposed to actually having a compelling legal argument for why you should win before the Court of Appeals. And speculation is always dangerous. If you're writing the response brief and you say, oh, the appellant, obviously didn't bring this to your attention because this is what they must have been thinking, well, then the other side gets a reply brief where they can say, that's not what we were thinking at all. Instead, the reason that we didn't raise it is because of this instead. And it makes you just kind of look a little foolish. And so that speculation is almost never necessary. If you have a compelling argument, just using the facts, using the law, makes your point just as effectively, and in fact more effectively than trying to speculate as to the inner workings of the mind of your opposing counsel or the district court. Another example of being unhelpfully adversarial on appeal is reflexively opposing everything. And this can come up both at the motion stage as well as when you're dealing with the briefing. So at the motion stage, for example, the other side asks for a 30-day extension. 9 times out of 10 at the Court of Appeals, that's going to be a rubber stamp, okay, for a 14-day or a 30-day extension. You really don't benefit much by firing off an angry, response to the court for why there shouldn't be an extension here. You're much better off letting that one slide and then asking for 14 or 30 days yourself when it's your turn to write your brief. If the other side's asking for additional pages or an extension to the word limit, that's one where you're probably best off just staying silent. Court of Appeals doesn't like having to read more. They're likely to reject that argument. But at the end of the day, what you say probably isn't going to make a whole lot of difference, and it's just going to clutter up the clerk's inbox even more with more things that they need to read. Sometimes it can be the case where the opposing counsel on appeal is one of those litigants who, filed 3 motions a week in the district court, and they can't help themselves, and they're doing the same thing at the Court of Appeals. They're trying to win this appeal through motion practice rather than on the briefs. And there may be 1 or 2 important ones where you need to respond if they're trying to supplement the record on appeal with things that clearly shouldn't be considered. That's something that you may need to respond to. But the clerk's office is going to get tired of seeing motion after motion. And if you're filing response after response, they're just going to get tired of hearing from you too. And so if you have an inclination that either, look, if the court grants this motion, I don't care, or there's a 95% chance that the clerk's going to deny it anyway, just let it go and stay silent. When it comes to the briefing too, if you agree with the other side as to the standard of review, what the key dispositive cases are, what the key facts are in the case, don't reflexively oppose everything. Instead, by agreeing that there's no disagreement there, you can do the court a huge favor and yourself a huge favor by being able to really narrowly focus in on what actually matters to the Court of Appeals. Because again, you're going to get 15 minutes of oral argument. You have a limited brief. If you can say this is the issue that matters, that's going to make the court's job easier and is a benefit all the way around. Another thing in terms of the briefing process is there can sometimes be this instinct that you want to swing for the fences. Here's the legal issue that, man, if we won on this, this would not only resolve this case, it would help us in all our other litigation. It'd be the home run. And the only problem is you have like this annoying thing called precedent that seems to be getting in the way of making that argument, or there might be policy reasons why a Court of Appeals judge may be unwilling to go that far. Don't be afraid to raise those issues in the brief, but also ask for a holding that the judge can feel comfortable reaching. Because if you have a sense that the issues you're raising are ones where you're asking the Court of Appeals to stretch, there are a lot of kind of judges who just have kind of this institutional instinct that they want to be incrementalist. They don't want to upset the balance too much one way or another. And so, raising that home run argument may make them more willing to consider kind of the safety valve fallback, but don't put yourself in a position where you're asking a judge to overreach, who at the end of the day is probably going to be unlikely to do so. And we'll wrap up in time here. Now oral argument. You can go to CLEs that are, for an hour long that are exclusively dedicated to this, but there are a number of ways that oral argument can go sideways. The first one is by wasting your first 60 seconds. Oral argument's going to go very fast. It's 15 minutes, and most judges like asking questions. And so your first 60 seconds are really the only time in oral argument that you can count on to be able to tell the court what you want to tell them. So don't waste it by getting up there and saying, Your Honors, I'm very pleased to be here today. This is my first time appearing before you. Traffic was bad, but I'm very happy to be here. My client is back here. If they just want to stand quickly, and you start doing that, and then you're going to get interrupted with a question, and you never got a chance to say what you actually wanted to say. So know your introduction cold and be ready to spit it out. And make sure that that introduction isn't going through the facts of the case. Go right into the legal issue immediately and focus in on that. Earlier we talked about the number of issues to raise in your appellate brief and talked about maybe 2 to 4 being a good number. If you go into oral argument saying there are 4 issues that I want to address in my oral argument, you're not going to have a good oral argument on any of them because you only have, again, 15 minutes or so. You want to know the one issue that you really want to talk to the court about, maybe 2, but don't go in with all 4. You also just need to know things inside and out. The goal in oral argument is to have a conversation with the court, and so you want to make sure that you're well enough prepared that you're not reading to the court. You also want to be comfortable enough communicating about the facts and the law of the case that you can have a conversation as opposed to getting defensive and argumentative. And you want to embrace questions. It might not be a question that you really like, but you need to answer it directly, yes or no, maybe a brief explanation why, and then you can always pivot to what it is you really want to say, but you need to answer it. The tricky thing with oral argument is you need to be prepared for a question on absolutely everything, even though only a fraction of that information is actually going to come out in court. And so just know that the preparation time is huge. And the best way to prepare for oral argument is to have at least 1, maybe even 2 moot courts in advance. And so bring in, attorneys, people you respect who don't know the case, are reading the briefs, and going to put the tough questions to you. I'd often recommend starting with an untimed moot where you might just go on for an hour or 2 of them drilling you with every single question, and you're going to feel so beat up at the end. But then you can go back and say, oh, well, I hadn't thought of this question. My response was a little bit shaky here, but here's how I can have a crisp response. Here's where I'm going to want to pivot to if that comes up at oral argument. And then maybe you have another moot court where now you feel better prepared. And then when oral argument comes, hopefully that's the least painful experience you've had, that the moots were far worse. Another important thing is judges like asking questions, hypothetical questions. Justice Lillehog on the Minnesota Supreme Court loves it. There's certainly plenty of Supreme Court justices who enjoy that. It's important that you know where you need to draw the line in the sand, because there's a real danger that when you're answering a hypothetical that you could concede your whole case away. And so, and so they might come at you with hypotheticals from a number of different perspectives. They might not like your answer at all, but you need to know where you just need to stick to your guns, because otherwise your whole case could unravel if you don't do that. The last one I'm going to mention, and so we should be done in time here real quickly, is a little bit of a different kind of pitfall. But when that Court of Appeals decision opinion comes down from the Intermediate Court of Appeals, there can be a danger in either hanging your head that you've lost if the opinion doesn't go your way, or of jumping up and down maybe a little bit too prematurely if you won. You need to know that there is another step, whether it's to the Minnesota Supreme Court or the United States Supreme Court. If you lost below, there are a few important things to think about. In the federal courts, you have options of a petition for rehearing en banc, or a petition to the Supreme Court. If you're thinking you want to go to the Supreme Court, go for rehearing first. At a minimum, it shows that you try to do everything else first before asking the Supremes to get involved. Petitions for rehearing are really effective if, let's say, the Court of Appeals ended up remanding back to the district court, but they have some misstatement as to what the record is. That's really going to be problematic for you when you go back down. And it may even look like it was just kind of an inadvertent throwaway from the Court of Appeals. If you go back to them and say, Your Honors, we're not challenging everything you did here, but this one sentence, if you could just change the language, here's why it should be changed. They're going to be much more amenable to doing that than you going in and saying that they're the dumbest judges in the world. For a petition for rehearing en banc, the key things you want to be looking for here are some sort of intra-circuit split, so maybe two Eighth Circuit decisions that have come out opposite ways, conflict with the Supreme Court. Petition to the U.S. Supreme Court, you would want to be looking for an inter-circuit split, so Eighth Circuit decisions different than the First Circuit, for example. If you're opposing, just realize that sometimes there's a value in keeping your head down, is the main thing I would emphasize. Especially at the U.S. Supreme Court, the U.S. Supreme Court is never going to grant certiorari without giving the other side an opportunity to respond. And so, if the Court of Appeals opinion is great for you, it's a short, unpublished decision, identifying no circuit splits, there's no dissent or concurrences. If the other side wants to try to take that upstairs to the U.S. Supreme Court, just file a waiver. It allows you to keep your head down. There's not going to be anything on the face of the petition that screams that certiorari should be granted. It's going to save the client money. And again, if the Supreme Court does have some interest in it, you're still going to get that chance to respond. So thanks. I hope this was helpful. I'll be around for a few minutes afterwards if anyone has questions. And again, if you haven't signed up, just please make sure you do so before you leave. Thank you.